Welcome to News Channel 45. I'm Leah Sabato and here with me is Karen O'Connor.
Breaking news. Judicial review is a hot topic this week, as there is a buzz occurring throughout the Supreme Court about exactly how much power this gives them.
To capitalize on this issue, we must go back in time in which the Constitution was ratified. The framers believed that a federal judiciary posed little threat of tyranny, and some delegates even suggested that provision of one was a matter of theoretical necessity.
So, the Supreme Court was essentially seen as ineffective, and today, in Article 3, the Constitution vests the judicial power of the United States in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish.
And the invaluable powers of this branch of government were not evident until Chief Justice Marshall's court from 1801 until 1835, in which John Marshall brought much needed respect and prestige to the court.
In this time period, the Supreme Court gained prominence and authority in the form of judicial review, the power of the courts to review the acts of other branches of government and the states. So, Karen, how was this established?
Why don't we turn to Alexander to the courtroom to find out?
In 1803, the court case Marbury v. Madison, in which the court first asserted the power of judicial review by finding the congressional statute extending the court's original jurisdiction, was unconstitutional. Let me break this down for you. This case began in March of 1801 when Federalist William Marbury was designated as a Justice of the Peace in D.C. Marbury and several other Federalist federal judges were appointed to government posts in the midnight hours of John Adams' presidency in an attempt to flood the judiciary system with Federalists. But newly elected Thomas Jefferson resented the Federalists appointed, and the appointees' commissions were not finalized and delivered by Secretary of State Madison. Angered, Marbury utilized the Judiciary Act of 1789's provision that allowed one to issue a writ of mandamus to sue for their jobs in court. The court ultimately ruled on three big questions. First, that Jefferson unfaithfully executed his powers by refusing to send the commissions. Next, the court ruled that Marbury did have the right to sue. But ultimately, Madison is the winner when Marshall decides that the writ of mandamus provision of the Judiciary Act was an expansion of original jurisdiction, which was illegal under Article 3 of the Constitution. This declares a law of Congress unconstitutional and established the precedent of judicial review.
Welcome back to the studio, viewers. Hopefully you all learned a thing or two about the Midnight Judges case.
Now that you've had some more background information, it's time to turn to our honorary guest speaker, President Barack Obama, for some more examples of judicial review.
Some examples of judicial review include Harper v. Virginia Board of Elections in 1966. Annie Harper did not have the funds to pay the $1.50 poll tax that is required to pay by Virginia law for voters to register. Harper sued the Virginia Board of Elections, claiming the poll tax violated the Equal Protection Clause in the 14th Amendment. This states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law, nor deny to any person within its jurisdiction the equal protection of the laws. The Supreme Court ruled that the Virginia law was unconstitutional because it hindered the ability of poor people to vote, which thus violated the 14th Amendment, which guaranteed equal protection. They ruled that the amount of monetary wealth an individual possesses should not affect their ability to vote. Another example is Liddell v. Galeo in 1994, when Margaret Galeo placed yard signs on her front lawn while protesting the war in the Persian Gulf. The city of Liddell had a law against yard signs and told Galeo to take her signs out. She sued the town under the terms that this violated the First Amendment rights. The Supreme Court ruled that the law was unconstitutional and it violated Galeo's First Amendment rights. These complete our examples of judicial review. Thank you and have a good night.